Okay, pan around. All right. Get up there. So, why is it ethical to try juveniles as adults? Have you ever heard of a crime so heinous, but that the person who committed it is not old enough to be tried into the adult criminal court? Have you ever heard of a crime that disgusts you so much that it hurts you to know that these people will walk on the streets the day they turn 18? Take a case, for example, out of Broken Arrow, Oklahoma. These two juveniles, one 16, one aged 18, murdered their parents, 52 and 44, and murdered 3 of their siblings, ages 12, 5, and 7. They murdered them by stabbed them over a combined 100 times. The 18-year-old is immediately sent into the adult criminal court, but what about that 16-year-old? What happens to that 16-year-old? That 16-year-old goes directly to the juvenile court system, but without the ability to transfer his petition, get a petition signed so that he can go to the adult criminal court system. He could not be tried as an adult that he committed knowing full well what he was doing. So juveniles commit serious crimes knowing what they are doing. So why are we not holding them responsible like we hold adults who would commit the same crime? Juveniles should be tried as adults in certain cases, and these cases would be for serious crimes such as felonies and for repeat offenders. It is ethical because the crimes are not impulsive. The juveniles repeatedly commit certain crimes knowing what they are doing, and then when they are of age, they should be tried and held responsible for the crimes they are committing. The juveniles will not stop committing these certain crimes unless they are adequately punished and held responsible for what they have done. The process for a juvenile to achieve adult status is relatively easy. It's just making sure that it's done. So according to Larry Mays and Rick Ruddle, who do the authors of Do the Crime, Do the Time, a book whose primary purpose is to inform the public about transferring juveniles to the adult criminal court, the 1959 Standard Juvenile Court Act stipulates the following preliminary steps in determining whether or not a juvenile can achieve adult status. The first step would be finding that the act would be a felony if committed by an adult. The second step would be a full investigation of the crime. The third step would be a hearing and a fair trial. And the fourth step would be finding that retention of jurisdiction would be contrary to the best interest of the juvenile and to the public. According to the National Criminal Justice Reference Service website, a service sponsored by the United States government to inform the public about the criminal court system, juveniles are transferred to the adult criminal court when the prosecutor or intake officer files a waiver petition. Once the petition is filed, the juvenile court judge then looks over the petition and reviews the facts of the case and to decide whether or not there is probable cause to believe that the juvenile did commit the crime. And then the judge will then decide whether or not the juvenile court jurisdiction should be waived and transfers the case to the adult criminal court. The decision to waive jurisdiction over the matter does not come easily to the juvenile court judge, and many aspects are taken into consideration. And many times, the judge's decision comes by whether or not the juvenile is amenable to treatment seen in the juvenile court system. Seen in many repeat offenders, the prosecution may argue that the juvenile has not been educated in the past and that the juvenile court system has not been able to stage an intervention to keep the juvenile from committing subsequent crime. A prosecutor may also argue that the crime is so serious that the juvenile court system will not be able to intervene for the time period necessary to rehabilitate the youth. According to Kathleen Michon, a juris doctor who records information to make it available to the public, many times a waiver is sent through a juvenile court judge to transfer the case to the criminal court, but while in many specific cases, the prosecutor may directly file with the adult criminal court system. This happens in very serious cases and only in certain states where it is legal to do so. So what are other factors in the process of trying adults as criminals? According to Justin Grogan, the president of the Tennessee School Resource Officer Association and a law enforcement officer with 20 years of experience, in most cases, how close the juvenile is to 18 is a big factor. Other factors taken into consideration are psychological illness and ill will, and to reiterate the importance of how serious the crime is. The case must also be a felony for the child to be tried as an adult. Although just because the case is a felony, it does not mean that the child will be tried as an adult. It is just a stipulation. So why is it ethical to try juveniles as adults? And how does this create a better world for us to live in? According to Richard Redding, a researcher for the United States Justice Department, by enforcing these transfer laws and holding juveniles accountable for their actions, we reduce the level of violent crime seen in juveniles. Alternatively, juveniles who are made aware of the ability for them to be transferred to the adult criminal court are less likely to commit a violent crime in the first place. Ultimately, keeping repeated juvenile offenders from the public is in the best interest of themselves and to the public. So what I'm asking you to do today is to see why it is ethical to try juveniles as adults and how it makes our world a better place. If we let them stay on the streets, they will continue to commit crimes that are heinous and detrimental to our society. Thank you.